Hello, my name is John Pinkowski, and welcome to a Florida Estate Planning Attorney's Guide to a Will Signing Ceremony. This will be a 1-hour CLE or Continuing Legal Education course by me, John Pinkowski, which will be appropriate for Florida attorneys who practice in the area of wills, trusts, estates, and related areas such as elder law practices and the preparation of wills and trusts. Today we'll be providing you with a probate litigator's perspective on a will signing ceremony. We'll be speaking for the next hour on the execution of your estate planning documents, your wills and trusts and other documents that you prepare for your clients in your Florida probate practice. So if you're an estate attorney or a probate lawyer in Florida and you write wills and trusts or draft or prepare wills and trusts, stay with me for the next hour or so. You'll get 1 CLE credit, a general credit from the Florida Bar, if you're a member of the Florida Bar. And I'll be speaking to you about this topic for 1 hour. So I'm going to give you that perspective today. And I'm going to be speaking to you for the next hour on this topic. By way of background, my name is John Pinkowski, and I'm with the Pinkowski-Hauser Law Firm in downtown West Palm Beach, Florida. Our law office is located at 415 South Olive Avenue. We just moved into our new building here, which is a block west of the Intracoastal Waterway, and within walking distance of the probate division of the 15th Judicial Circuit for Palm Beach County in West Palm Beach, and we're a few blocks away from the federal courthouses as well. At Pinkowski-Hauser, we limit our practice to probate litigation, disputes, trials, and appeals involving wills, trusts, and estates, and related matters such as real estate and homestead and some family business interests. I invite you to attend free of charge other Florida CLE seminars that Pinkowski-Hauser offers. I've done a number of webinars for the non-public or the non-lawyer public on different probate topics. And I've also done a number of free Florida CLEs for Florida bar members and practicing attorneys, mostly for Florida lawyers who have an estate practice or a probate practice. So to learn more about free CLEs on probate and estate topics in Florida, you can email Amanda at phflorida.com. That's Amanda Phillips. Amanda at phflorida.com, or you could dial Amanda at 561-514-0900. Amanda's extension is 101. You could also go to our website, phflorida.com, P like Pinkowski, H like Hauser, Florida.com. Click on webinars and videos, and you'll get a link, and you'll also get the course identification number, so you'll get credit from the Florida Bar. So with that said, why are we here today? Well, as probate litigators, we at our law firm hope to provide some perspective to you, the estate attorney, the drafting attorney, the Florida lawyer who has an estate planning practice. You prepare estate plans, you write Florida wills and trusts. And we want to try to give you the perspective on your preparation and presentation of your wills and trusts to your estate planning clients, right? So we're going to be sharing with you some of the issues which we, as probate litigators in Florida, come across. And what we hope to do is to leave you today with maybe some best practices, maybe some improvements or some new issues that you can use in your firm, your probate practice, your estate law practice, that will help you improve the services which you're providing to clients, and also which hopefully will assist you with keeping the integrity of your documents, right? Because the reason we're having this discussion in CLE today is because our law firm, Pinkowski-Hauser, is an estate and probate litigation law firm in Florida, and we handle a lot of will contests, right? And probate litigation, by all accounts, seems to be rising, right? And so whenever we have a will contest or a trust contest or a petition to revoke probate, That can be a highway to heartburn for a lot of estate planning attorneys because your documents are being called into question, and indeed how you practice is being called into question. How you conduct or don't conduct a will signing ceremony, how you have a client and witnesses execute or sign a will or a trust is being called into question. And finally, how you safeguard or keep or don't keep the original will may be called into question. So let's talk about our discussion outline for a minute. Then we'll go right into the first topic. We've only got about 9 topics today. The first one is an introduction. After the introduction, we're going to be speaking about, well, why do you even need a will signing ceremony? Why is P.L.L.C, a Florida estate litigation attorney who has a practice devoted to Florida inheritance lawsuits, why is he talking about a will signing execution or ceremony, and why is he even calling it a ceremony? We'll then discuss what a will signing ceremony is. We'll talk about, probably for about a half an hour, on different aspects of the Florida probate code that are applicable to will contests, trust lawsuits, trying to revoke probate or overturn a will, or filing a challenge to a will. And we'll try to give you some perspective on those aspects of the Florida probate code that you'll be questioned on if your documents, your will or your trust are attacked, right? If there's a challenge to your will or your trust. And the context for all of this, the background, is the following. You've prepared a will or a trust for a client, and the client has now passed away. The original will of the client has been filed with the clerk of the county where the decedent resided at the time of his or her passing, and there's a will challenge. Somebody is objecting to the Florida will. Somebody has filed a petition to revoke probate and is challenging the Florida will and arguing that it's void or not valid. I'll speak a little bit about anticipating Florida probate lawsuits, and then talk about 7 important factors to consider regarding a will signing ceremony. You're not going to be thrilled with those 7 factors. They're amazingly obvious, but they're things to keep in mind. And after hearing me speak for 40 or 50 minutes by that point, hopefully you'll gain some perspective about why a will signing ceremony and these 7 factors are important to consider. I'll speak later about videotaping will signing ceremonies and give you, I think, some very, very pointed commentary on that. And then finally, I'll be talking about lawyer as witness after the passing of one of your clients when there is a will contest or an objection to probate or a trust lawsuit challenging the validity of the trust. You, many times, the drafting lawyer, become the most important person in the room. You're often, many times, the first witness who gets called or gets called to the stand. And certainly, many times, you're the one that the probate court judge who's conducting the will contest trial in Florida wants to hear from. Okay, with that said, let's go into our introduction. Why are we here today? I'll give you 56 trillion reasons why we're here today. That's the dollar figure that the Boston College Center on Wealth and Philanthropy has estimated is being passed from the World War II generation to successive generations right now and over the next 10 or 20 years. $56 trillion that is being passed from the World War II generation to the millennials, Gen X, Gen Y, and others. And many people are fighting over it, and they're hiring lawyers like myself and my law partner, Robert Hauser. You can see the slide in front of you is a photograph of Rob and me at our old law office at 120 South Olive Avenue. We occupied the 7th floor there, and you can see the City Hall dome in the background. We've since left that office and now occupy a building we own at 415 South Olive Avenue. So everyone seems to be fighting over wealth and inheritances, and they're going to probate court to enforce those rights. And so we do see, for good or for ill, probate litigation being a growth industry. Also, and perhaps of more personal importance to you, the Florida estate planning lawyer, the number of lawsuits against estate planning attorneys seems to be on the rise, right? Once originally thought immune, now probate lawyers, estate lawyers are not immune. I gave a CLE on malpractice in the Florida estate context, the Florida will context, the probate context, back I think in December of 2016. And I think that was an hour and a half. And you can get ethics credit for that as well. And I talked all about the issues of suing an estate planning attorney for purported malpractice and the hurdles, procedural and evidentiary hurdles that are changing and evolving, right? The law in Florida is evolving, and I think it's going to continue to evolve when we talk about whether an heir, a beneficiary of an estate, or a deceased person can sue a decedent's estate planning lawyer. And so you've got all these probate wars, right? You've got all these different estate lawsuits and inheritance conflicts and inheritance fights that are being played out in the courts of Florida every single day. That is the background or the backdrop of why we're here today. So why a ceremony? Well, in short, because your documents are the ones that are being questioned, and how you have a client sign a will or not sign a will is very, very important to the judge. And in a will contest or in any proceeding where you question, or excuse me, where someone questions your will or your trust, you're going to be in the witness stand, right? You're at least going to be deposed, and you're certainly going to be called to testify at trial, either by one side or the other. And you, the drafting attorney, without exaggeration, often become the most important witness in the room, right? So how you handle the signing of a will or a trust that you prepare for a client is very, very important. What are your practices and standards? Do you have a procedure? Do you handle it personally? What do you say to people who are there? What do you not say? Do you ask people questions? Do you keep an execution memo? Do you keep a contemporaneous writing reflecting who was there and what was done? Why a ceremony? Because you are going to be examined by someone's lawyer when your documents are called into question. When somebody alleges in a probate lawsuit or an estate or an inheritance case in Florida that the will that you prepared for a client is void, you're going to be asked about that. And how you manage or don't manage the signing of that document that you prepared for your client becomes very, very important. So what is a will signing ceremony? Well, you might argue that the word ceremony is a bit too dramatic, but I don't think so. To me, a will signing ceremony suggests that there's some practice or procedure, there's some organization to presenting a client with a will or a trust, gathering the witnesses, having that person sign the will, having the witnesses sign the will, and then having the notary notarize the signatures on the self-proving affidavit. All very, very important. And so a will signing ceremony is how you conduct yourself and how everyone else conducts themselves in that room or that place where that will is signed. And so as a probate litigation attorney who handles inheritance lawsuits in Florida, when I'm involved in a will contest, either representing the plaintiff or the petitioner, somebody who's objecting to the will and seeking to set aside the will, or defending the document. Maybe I'm defending you individually the estate planning lawyer, because you're concerned, maybe you're personal representative of the estate, or what other states call an executor of the probate, and maybe you want firepower. Maybe you want independent counsel representing you as PR in the will contest. Or maybe you're concerned that you individually and personally may have some exposure, and you want a lawyer by your side throughout that entire trial because you're concerned that whoever loses may seek redress from you, right? They may sue you. So, or maybe my probate law firm in West Palm Beach was hired to represent a beneficiary under the will that's being attacked. And they're saying, John, I'll pay you out of my own pocket. Go in there and fight. I'm interested in the estate. I'm a beneficiary under the will. Support the will. Thwart the attack. Fight the challenge to that will. And maybe they want to get involved. They want me to get involved in that will contest. So I've got questions, right? There's things that I need to know. And one of the first things that I want to know is who are the witnesses, who's the notary, who's the drafting attorney. Then I want to find out about the will signing ceremony or the circumstances surrounding the signing, the presentation, the execution, the witnessing, notarization of that document. And so I'm going to ask questions like, well, who was there? Did anyone enter or leave the room at any time? Who arrived first? Who arrived last? Who signed the document first? Right, in Florida, ask any Florida estate lawyer, and they'll tell you that one of the requirements for a valid will in Florida is that the client sign it in the presence of two witnesses who sign it in the presence of the witness and in the presence of each other. And so I want to know what happened and when in that execution ceremony. Who signed first? Who signed next? Did everybody watch this? Was there a procedure? Or can no one remember? Or do they have their facts wrong? And do they contradict each other? Who signed first? Who signed next? Who signed last? What was said? Who kept the original, right? Estate lawyers seem to fall into two camps. There are those who always keep the original because that's their practice. They like to do that. They put their client's will in their vault. They might give them a receipt. And there are others who say, we don't want to keep any originals. You keep them. We have hurricanes in Florida. Some people think it's become harder to safeguard original documents, notwithstanding that there's safes and vaults and blah, blah, blah. But they just don't like to keep originals, and so they make sure the client keeps the original. Do you have a writing to the client confirming that? Do you have a writing to the client after the signing of the will saying, oh, by the way, you kept the original, right? Do you have something in your file so that when the client passes, and it may be years from now, if somebody comes knocking and says, do you have the original will, you can say, clearly I don't, or yes, I do, and here's why. In addition to confirming things in writing after the signing of the will, like a letter to the client saying, we signed your will, you kept the original, do you ever reduce what transpired at the execution ceremony in a memo, a contemporaneous memo, executed, drafted, prepared right after the signing of the will, a so-called execution memo, that while your memory is fresh and your knowledge of the signing ceremony is clear, you're able to reduce to writing what occurred. Having an execution memo, having a confirmatory letter, those are all important facts from which a trial court, a probate court judge hearing a will contest or a will attack lawsuit in Florida can draw inferences and make findings of fact as to whether the will is void or invalid or not. Okay, let's get into part 4, understanding the Florida Probate Code. We're going to spend a little bit of time now talking about the Florida Probate Code, particular sections of the Florida Probate Code, and we're also going to talk about a few cases: the Carpenter case, the Levin case, RBC Ministries case. Not a lot of time, but a little bit of time, because I think they're worth our time. So let's talk about undue influence first, right? And why are we talking about undue influence? Because undue influence is one of those ways that you can set aside a will, right? And so a will is actually void, not voidable, but void if it's the product of undue influence. You can take a look at Florida Probate Code 732.5165, right? A will is void if the execution is procured by fraud, duress, mistake, or undue influence. And mistake is not the mistake that most non-lawyers think is a mistake. You know, I gave half of my estate to my son John. Oh, that was a mistake by Dad. He really didn't mean to give him half. A mistake in this context is, I signed that will. I thought I was signing a power of attorney. I swear to God, I didn't know I was signing the will. Fraud, duress, undue influence, those are other ways that a will can be void. But remember, with undue influence, when you're in a court of law in the middle of an undue influence trial in Florida, undue influence is a species of fraud, and whoever files a lawsuit involving undue influence is required to plead it with particularity. That's the Van Meter case. So keep that in mind, right? It's a species of fraud, and other courts in other states follow that as well. So when we're speaking about undue influence, we have a number of issues that always come up. And one of the first cases that comes up is the Carpenter case, right? It's a 1971 Florida Supreme Court case. That's an undue influence case. And the Florida Supreme Court lists a number of Carpenter factors that may or may not be appropriate for a probate court to assist it in determining whether a document was procured by undue influence. Now, you can read the Levin case, L-E-V-I-N, 60 Southern 3rd, 1116, 60 Southern 3rd, 1116. It's a 2011 case. It's from Florida's 4th District Court of Appeal, and it involves undue influence, and it cites the estate of Carpenter, which is 253 Southern 2nd, 697. So when a will is challenged on the grounds of undue influence, what does that mean, right? Because influence isn't enough to void a will, right? You can ask your dad or your mom to give you a larger inheritance. There's no problem there. But when the influence, and you can even put a little bit of pressure on mom or dad. Come on, mom. Come on, dad. You know I love you. You know I need the money. Can't you put me in the will? Give me more. That's not so bad, right? But when that influence amounts to over-persuasion, duress, force, coercion, or artful or fraudulent contrivances, to such an extent that there's a destruction of free agency and willpower, that's not good. That's undue influence, and that can make a document void, right? That is where things can get very, very bad. So you can look at the RBC Ministries case, 974 Southern 2nd, 569, 974 Southern 2nd, 569. It's a 2008 case from Florida's 2nd District Court of Appeal. And the RBC Ministries case talks all about undue influence. It cites the Carpenter case, and it presents to us some maxims or some legal concepts that we're very familiar with in the world of undue influence. And if you ask any probate litigation law firm attorney in Florida, they can recite these legal maxims off the top of their head. So let's run through some of them now, okay? A will or any portion of a will procured by undue influence is void, right? So that's very important. Many times you'll see in a will contest or an estate lawsuit in Florida that somebody might be objecting to the whole will, or just the residuary clause, or just a specific devise or pecuniary devise. See Florida Probate Code Section 732.5165. The entire will does not have to be the product necessarily of undue influence. You may be able to set aside or have declared void a portion of that will, a particular provision. So when we're talking about undue influence, we're talking about such force or coercion that really hampers the free agency of the person who's being abused, right? And so the document that comes out of that undue influence really isn't the expressed intent of the person who signed it. It's the expressed intent of the person who's unduly influencing the person who's putting the pressure and coercion on the person to sign the will or have the will made. We know that there are some requirements for undue influence. One, if you believe somebody committed undue influence or unduly influenced someone to sign a will, that person, the wrongdoer, has to occupy a confidential relationship with the person who signed the will. Right? There has to be some type of confidential relationship. And this probably goes without saying is the person you're accusing of undue influence, he or she must be a substantial beneficiary under the will. And, you know, look, we've all had trials where one of the issues is, hey, look, I don't disagree that so-and-so is a beneficiary, but they're not a substantial beneficiary. And so if you have somebody who's a substantial beneficiary under a will, who is in a confidential or fiduciary relationship with the person who signed the will, and if they were active in procuring that will, then a presumption arises that the will is invalid based on undue influence. So you have those three prongs, right? The three-prong test: substantial beneficiary, confidential relationship, active in the procurement of the will, right? Who hired the lawyer? Who paid the lawyer? Who called the lawyer? Who told the lawyer what to put in the will? Who coordinated the witnesses? Who coordinated the execution? Who kept the original? All questions your estate litigation attorney is going to ask in a will contest case or a petition to revoke probate trial in Florida. And those are many factors that you have some control over if you're preparing a will, right? Are you taking a call from a non-client who's giving you instructions on what to put in a will for a client? Are you getting paid by that non-client? Are you taking instructions from that client, or excuse me, that non-client, of when this document will be signed or how it should be changed or who it should be mailed to? Are you permitting somebody to procure a will for somebody else? Now, in RBC Ministries, you can see the whole Carpenter laundry list of non-exclusive factors or criteria which are relevant to determining whether a beneficiary has been active in procuring a will, right? Those are all listed there, right? The presence of the beneficiary at the execution of the will, right? That's something you have control over. When you meet with a client individually, you can kick everybody out of the room, or you can permit anyone you want in the room to come in. Presence of the beneficiary on those occasions when the testator, the person who made the will, expressed a desire to make a will. Right? Did you speak with the client alone when the client says, I want to change my will? Or was somebody else there? How did you get this job? Was it a longtime client? Or was it a new client who was referred by somebody else? Or did you get that client through this substantial beneficiary? Did this substantial beneficiary have knowledge of the contents of the will prior to it being signed? And there's other criteria that are listed in RBC Ministries, citing Carpenter as well. And so this rebuttable presumption, which you can read more about at Florida Probate Code Section 733.107, supports the state's public policy against abuse of fiduciary or confidential relationships. Let's talk about lack of capacity now. That's another way to have a will declared invalid or void, right? Why? Well, read Florida Probate Code 732.501, right? You can ask any estate litigation attorney in Florida who can make a will, and they'll tell you, well, you've got to be 18 and you've got to be of sound mind. Well, what the heck does sound mind mean, right? That sounds kind of like an archaic term, right? An archaic legal term. Now we talk about capacity, right? Now we talk about whether somebody who signed a will understood what they were doing, knew who their family members were, knew in a general way the dispositive nature of the will that you prepared for them, and knew in a general way their assets and extent of their wealth, their properties, right? So 732.501, a very important provision that's often read once and only once, but you need sound mind to make a will in the state of Florida. And so you, as an estate planning attorney, a probate lawyer who drafted a will, your interaction with your client's very important, right? Your estate litigation law firm in Florida, when they assign a lawyer to handle a will contest, is going to ask you, what did the decedent say to you? And what did you say to the decedent when you were discussing preparing a will? Or at the execution ceremony, at the signing of the document, did they say anything to you? Did you say anything to them? Were any questions asked? Was an examination conducted? You know, there's some estate lawyers in Florida who ask the person the date and who the president is, and they conduct a little mini examination to try to get some comfort that the person who's going to sign the will is competent. You know, did you speak to the person signing the will about the date, the time, the place? They oriented as to time, place, location. Did you ask him about family members? Did you ask him about what the nature and extent of their wealth or property was, what they were doing here today? What's the purpose of today's meeting? So, you know, ideally, right, if you want your document upheld, you want the person who's signing the will to describe specifically what you're doing there today, who their family members are, and how their wealth or property is distributed or not distributed by the document that they're signing. All these things matter, right, in light of the Carpenter factors. And so asking yes or no questions generally isn't that helpful or informative, but asking for detailed answers or getting detailed answers is very informative. How do you conduct the signing of a will in light of potential will and trust contests, right? How do you conduct the handling of a will signing ceremony so that the integrity of your documents are upheld? And so if your question is a witness, if your document is questioned or attacked by an estate litigation lawyer in Florida, are the facts such that your document will be upheld? An insane delusion is another way in which a will may be declared void, right? When there's an insane delusion in regard to one, for example, who is a family member, right? The object of the testator's bounty, a beneficiary. And that delusion, we need some cause here, right? We need a link. We need a link. That insane delusion causes someone to make a will or to write a will in Florida or provision that he wouldn't have done or she wouldn't have done but for that delusion, then that will cannot be sustained, right? That's the Miami Rescue Mission case. That's a Florida 3rd District Court of Appeal probate appellate decision. It's out of Miami. You can also read the Levin case, right? We talked about Levin a little while ago about undue influence. It's still important for purposes of insane delusion. And so you're probably, asking yourself, what are examples of insane delusion? Well, in the Levin case, the insane delusion that the appellate court dealt with in that probate appeal dealt with whether a mother, dealt with a mother persisting in a belief that someone had only visited her once in like 10 years, that somebody had not been visiting her, and had the person who signed the will had not seen somebody in anywhere from like 10 to 11 years. And that's an example. Other examples from another case include a belief that this caretaker was not taking care of me, was not caring for me, not coming to see me, not attending to me, when in truth the caretaker was. Right? You're under this insane delusion, right? A repeated incorrect assumption or delusion. And that delusion is linked. It might be linked to reducing someone's inheritance or to eliminating someone's inheritance. When there's an insane delusion present that's linked or causes to affect someone's Florida inheritance, you may be able to have that will thrown out. Now, anytime I hear of insane delusion, and you can ask your estate litigation attorney in Florida about this, insane delusion to me often can be linked to a reformation action of a will. In Florida, you can reform a will, which to, probate lawyers in Florida, they've known this for a few years now, and, I guess it doesn't faze them that much. But to the non-lawyer public, it freaks them out, because what reformation really means is a court can change your will, right? And we used to think that wills were inviolate. You can never change them after you die. Change them while you're living. But now you can change a will after somebody dies. But there are limited circumstances, limited conditions. And so if you think you have an insane delusion, you have to think about whether a will or a provision in a will was the product of a mistake. And can you reform that mistake? Can you reform a mistake of law or a mistake of fact under Florida's probate code and Florida's reformation law for wills, section 732.615. Lost or destroyed wills. When is an original not an original? And I got to tell you, we get lots of calls from wonderful prospects all over the country, not just Florida, who are involved in a Florida probate or an estate. And one of the things that I always see is they don't know where the will is. Hasn't been filed yet. Or if it's been filed, they haven't inspected it yet. And I got to tell you, a lot of people misunderstand what original is. An original will has ink signatures that are discernibly ink. And when you hold up the signature, you can see the ink, and you can see the internal lines of the ink and the ballpoint. And when you hold up the paper or the will, the signature page to the light, you can see the indentation in the parchment, the paper, from where the ballpoint or the magic marker was when the person signed it. Original, one and only, not a copy, ink signature will. That's the original. I can't tell you how many people view a copy as an original incorrectly, right? There's only one will, there's only one original. The rest are copies. And some people, lawyers, even file copies of wills. And so you need to know whether we have an original will or not. Because if you don't have an original will, well, if you have an original will, then we've got to determine whether it's valid or not. Right? You leave that to your estate litigation lawyers. If you don't have an original will, then the question becomes, did the person die intestate? Do the laws of intestacy in Florida apply such that heirs, H-E-I-R-S, Florida heirs, inherit the estate? Or is somebody going to file a petition for a lost or destroyed will? Right? Under Florida Probate Code Section 733.207, you could establish, you can even probate, a will where there is no original anymore. It's been lost or destroyed. Knowing who took the original and where it is an important part of your estate planning practice. Do you keep the originals? Does your client, who kept a particular original on a particular date, having a will signing ceremony and an execution memo created contemporaneously with the signing of the will and the safeguarding of it, which recognizes this, reduces this to writing, memorializes it, saves everybody a lot of pain afterwards. Remember, there is a rebuttable presumption about lost and destroyed wills, that if a will was last seen in the possession of the testator and it's no longer found, there's a presumption that it was destroyed. Those are issues of evidence, right? They're evidentiary issues and procedural issues for your probate litigation law firm in Florida. Statutory formalities, right? That's kind of the boring, non-sexy part, right? The testator or the person who's making will is going to sign it at the end. If they don't sign it, you don't have a will. Can't tell you how many times people have called up and said, no, we got a will, it was prepared, just didn't sign it, or didn't sign it at the end. You don't have a will. Where did the witnesses sign? I need 2 witnesses. And you're probably going to have a self-proving affidavit. In what order did they sign? And one of the requirements under Probate Code 732.502, right? If you want to read about this signing of wills and how Florida wills should be signed, read Florida Probate Code 732.502. Right? The attesting witnesses must sign the will in the presence of the testator and in the presence of each other. And you have these cases where you question, well, what does presence mean? Does it mean physical presence, like geographic presence, like I have to be within 2 feet? Or can I be way down the hall but still see the person sign? Or is way down the hall too far? It's not in the presence of the testator. Or what if you're in a lobby or a room that's next door to where the person's signing it? How close do you have to be and what do you need to see for witnesses to sign in the presence of the testator? Let's move on to our 5th topic, anticipating Florida probate lawsuits. Look, for good or for ill, more people are apt to question things than ever before. They're certainly more apt to question a lawyer than ever before, including a probate lawyer. They're more apt to question a will or a trust or a dispositive provision. And that leads to a lot of will contests and will challenges, right? It creates a lot of probate litigation that, that all lead to probate trials in Florida, right? That lead to not only trials, but appeals. That's a picture of my law partner, Rob Hauser, board certified in appellate law, arguing before Florida Supreme Court in 2016. So at your probate trial or your inheritance lawsuit trial, be mindful that if you win, how can you preserve your appeal if the losing side appeals? And for God's sakes, if you lose, did you preserve all your issues for appeal? right? So you as an estate planning attorney, many times you can anticipate Florida probate lawsuits because many times you know who the troublemaker in the family is, or you know who got disinherited and may be likely to raise an objection. So how you handle a particular estate plan is important. How you handle a particular client is important. Because you probably know better than anyone other than the immediate family members who's going to fight whom when mom or dad die. And what you do or don't do or interact with those people and family members are important facts that will affect any will contest case. 7 important factors to consider regarding a will signing ceremony. And so now we're on a fast downward slope here to conclude our CLE for Florida probate lawyers. So you're not going to find any of this next topic particularly exciting or new, but it's important. Did you proofread the will? Hand of God, just yesterday I read a trust. Typos, errors, nonsensical, gibberish in certain provisions. It was not proofread. Nonsensical, in other words, meaningless provisions. Did you proofread it? Is it accurate? Remember, if your will has typos or it has nonsensical provisions or there's provisions that are meaningless, that affects your credibility in court when you're called as a witness, right? And if somebody is already attacking your document and saying dad didn't know what he was doing when he signed the will, or, you know, mom was under the undue influence of somebody when she signed the will, by not proofreading the will and correcting any typos or meaningless gibberish, that affects your credibility. You need witnesses and a notary. Who's going to get them? If you're conducting the execution ceremony, the signing of a will, you should, right? You shouldn't let a beneficiary provide the witnesses. And you may or may not have the testator provide the witnesses. But who are those witnesses? Are they good, solid, intelligent legal professionals who are capable of concisely remembering everything and providing competent testimony? Who's your notary? Was everything explained clearly? And is everyone in the same room for the ceremony, right? I know some lawyers have a good practice of having whole sets of standards and procedures, informal as they may be. Here's what we're doing today. John, can you tell me why we're here? What are we doing here today? This is how we're going to do this. Boom, 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 boom. He or she is running the ceremony, in charge. The general makes things more organized and more focused. Remember, the testator or the client actually needs to sign the Florida will and needs to sign it at the end in the presence of witnesses. And you need to have the witnesses sign the will. If you have one witness, it doesn't work. Although there's case law out there that says if there's a notary present, the notary may or may not be a witness. And then they should sign the self-proving affidavit. And then who's going to store or accept the original will? We talked about that a little bit earlier. So be prepared, right? Consider having an execution memo that you prepare and save shortly after or immediately after the will is signed, that tells us all these things. Who was present, who signed, who did this, who kept the original. Very, very important, who kept the original. The myths and reality of videotaping will signing ceremonies. I think lawyers fall into two camps. They either love them or hate them. If you're going to have it videotaped, make damn sure that your witness plays well on video. If your witness is hammering and hawing and gibberishing and not speaking coherently and forgetting things and pausing and getting off track or not focused, the purpose of the video is probably not going to be fulfilled. And sometimes you don't want to videotape people signing a ceremony because the purpose you're hoping to achieve is not achieved. And the effect of the video is quite the opposite. Be cautious about the script or the questions that you're going to propose to the witness, the person who's signing the will. If you ask him or her yes or no questions, it's not that helpful. If you ask them questions that permit the person to give detailed, thorough answers, that seems to demonstrate that they're competent, right? And that seems to provide or accomplish the purpose of the video, right? The general purpose of the video is, I want to keep a clear record so there's proof that this person knew what they were signing. Very, very powerful in an estate litigation lawsuit or an inheritance trial in a Florida court. But if the video is not done properly, you can really backfire. Lawyer as witness. You're going to be called to testify. You can be deposed. You're going to have to give up your file. Why? Because our legislature says so. There is no lawyer-client privilege under, Chapter 90 is our evidence code in Florida. Under 90.5024B, when people claim through the same deceased client. You can also read a more recent attorney-client privilege case in Florida out of Miami, Florida's 3rd District Court of Appeal, the Vassallo v. Bean case that talked about this very subject. 208 Southern 3rd 188 is the Vassallo v. Bean case. I argued an attorney-client issue for a drafting attorney and estate planning attorney whose file I wanted in a will contest case before the Vassallo v. Bean case came out. And notwithstanding the plain language of the evidence code, some people still struggled with that concept that there's no lawyer-client privilege when people claim through a deceased client. So thank you for attending this 1 hour Florida Bar approved or accredited continuing legal education course sponsored by P.L.L.C. Hauser. My name is John P.L.L.C. I'm the managing member of P.L.L.C. Hauser in downtown West Palm Beach, Florida. 561-514-0900. My email is john@phflorida.com. Your reference number for today's Florida Bar accredited CLE is 170168. N is in Nancy, a Florida estate planning attorney's guide to a will signing ceremony. The certificate of accreditation is in front of you on the screen. The Florida Bar course number is in front of you on the screen. And I'll close by thanking you for listening to us. And if I can ever be of any assistance regarding any Florida probate litigation or appellate issues, please feel to give me an email or give me a call. My name is John P.L.L.C. of P.L.L.C. Hauser. I'm an estate litigation attorney in Florida. Thank you for listening.